The matter of the parentage of DD, a minor child by and through his next friend and father, Daniel Allen Dester II, petitioner, Mackenzie Martine, respondent, case number 2023 DM 409. Beginning with petitioner, would counsel announce appearances for the record, please?
Yes, thank you, Your Honor. Daniel Allen Dester II appears by and through counsel Mindy Ellen Wheeler, both appearing by Zoom.
Respondent Mackenzie Martine appears by and through counsel David Morgan, and she's also here in my office today participating in this hearing.
Counsel, are there any agreements that have been reached regarding the issues raised by the motion?
Well, Your Honor, I'll start. It appears we're very, very close, but we had prior orders and a judgment. We were very close. We never got them finalized. Some new things happened, and then we filed this motion to terminate father's time. We have received some information recently, and we haven't been able to agree on all terms. I guess I need to ask Ms. Wheeler if our final terms were acceptable.
Without going into too much detail based on those terms, I'll tell you that the second option you gave me, my client does not agree with, but would agree with the counter proposal I made to you.
Okay. Then we don't have an agreement, Your Honor.
Okay. All right. I was interested in the word you used earlier, Mr. Morgan. You're going to terminate the father's parenting time?
No. Well, he hasn't been seeing the child, so what we are asking the court is to terminate his time temporarily
Or in
and
other words, suspend his time.
suspend his time. Okay, I'm sorry. Suspend his time, and I would set this for a full hearing where at some time we can come in and address every issue.
Before this courtroom even settles, understand what's really at stake here. This is not just another family court hearing. This is a high-stakes battle over parenting time, trust, and the future of a 3-year-old child caught between two very different narratives. On one side, a father fighting to restore meaningful time with his son. On the other, a mother raising serious concerns about safety, alcohol use, and supervision. And standing between them is a judge tasked with balancing constitutional parental rights against the best interest of a child who cannot yet speak for himself. This case unfolds slowly, deliberately, and with tension that builds beneath every word. Allegations surface, explanations lag behind, and unanswered questions linger longer than anyone is comfortable with. You'll hear references to DUIs, probation, supervision agreements, and emotional trust that may already be fractured beyond repair. But here's the twist. Much of what's being argued isn't about proven harm, but about fear of what could happen. And in family court, that distinction matters. Stay with us, because by the end of this hearing, the judge delivers a message that every parent watching needs to hear.
Resolve every issue. If father thinks he is able to see the child first on a supervised basis, he will have his chance to present his case to the court, and the court can rule. But that's what we're asking the court today.
Mr.
Suspend
Morgan,
his time.
Okay, just a moment. Isn't there already an agreement in place where he has supervised visitation?
Yes,
Well, if it's supervised by responsible adults, why would there need to be any curtailment of his parenting time at this point?
because we've had received information that his parents weren't supervising his time at all times. And we hope to see father take the better road. Other things have happened since then where he has.
At this moment, something important becomes crystal clear. There is no agreement. And in family court, that changes everything. What could have been a procedural hearing instantly turns into a strategic standoff. Both sides acknowledge they were close, but close doesn't count when a child's schedule, safety, and emotional stability are involved. The court is now required to step in, not to rubber stamp a deal, but to actively evaluate risk. Notice how language matters here. The word terminate is immediately walked back and replaced with suspend. That distinction is not accidental. Termination suggests permanence. Suspension suggests caution. It signals that one side is asking the court to hit pause, not because something catastrophic has already happened, but because they believe warning signs are flashing. This is where judges lean forward. When cooperation breaks down, credibility, and evidence suddenly matter far more than intentions. And from here on out, every claim made will be weighed carefully against what can actually be proven.
Shown that he's still drinking, he's being irresponsible. We don't trust that he's being unsupervised, therefore he's caring for the child. We believe it has raised itself to a safety risk and suspend his time, but give him a hearing where he can come in and prove the things that he needs to prove to have time. Now, if he is not seeing the child now, he has not seen the child since I think the 1st of August. If we do go back to supervised, we would like to go in a step-by-step method and start with every other weekend only. The child goes to school, he's used to this schedule. We would recommend that if the court says, well, let's continue with supervised, that he only have every other weekend and then step it back up to.
This is a pivotal exchange. The judge asks a simple but powerful question. If visitation is already supervised, why does it need to be curtailed further? That question cuts straight to the heart of the dispute. The response reveals the underlying tension, distrust. Allegations that supervision wasn't truly happening, concerns about ongoing drinking, and fear that safeguards exist only on paper, not in reality. What's critical here is that none of these claims involve the child being directly harmed, yet. Instead, the argument rests on perceived risk. Family court often operates in this gray zone, where judges must act before something irreversible occurs. But suspicion alone is never enough. That's why the court repeatedly emphasizes hearings, evidence, and step-by-step approaches. This isn't punishment, it's prevention. And the court is clearly signaling that any restriction on parenting time must be proportional, justified, and anchored in the child's daily routine, especially school stability, even at just 3 years old.
Where there might be one day during the week because the child is accustomed to a school schedule now.
Even though he's only 3?
Yes, he does go to school.
Yes,
Every day,
except for Friday.
except Friday.
All right. Ms. Wheeler, some concerns have been raised. What is your response to Mr. Morgan's presentation?
Well, my response would be there are no reasons here to terminate or suspend my client's parenting time. Miss Martine, the mother, actually chose to end the supervised parenting time, making certain informal allegations that haven't been supported by any evidence that I've seen regarding the parents not supervising. My client, in the meantime, was working towards resolving some of the conditions in the.
Here's where the narrative fractures into two competing realities. One side paints a picture of alarming behavior, photos, rumors, unanswered questions, and lingering doubts. The other side pushes back hard, emphasizing lack of evidence, resolved conditions, and documented compliance. This is classic family court conflict, emotion versus documentation. Pay close attention to how defense counsel frames the argument. She doesn't deny the court's concerns, she redirects them. She grounds her position in paperwork, timelines, and verifiable progress. That strategy matters because judges don't rule on feelings, they rule on records. The phrase, "It is very hard to prove a negative," is especially important. Courts cannot punish someone for charges that do not exist or allegations that never materialized into formal findings. This exchange sets the stage for the judge's ultimate balancing act, acknowledging fear without letting it override constitutional parental rights.
Prior agreement that we had for supervised visitation and how to move past supervision. Just last week on Monday, a week ago today, he resolved one of the final pieces of that, and all of that information was shared with Mr. Morgan and his client. Or I'm assuming Mr. Morgan shared that with his client. I don't think that there's any reason to delay adopting essentially what Mr. Morgan has included in his proposed or in his exhibits. He submitted a proposed order that is very much similar to the version that we had agreed to and executed for him. We've since had some discussions. The only thing that seems to be hanging this up at this point in time is if we allow supervised visitation, which I think by the agreement and the prior conditioned order.
This portion of the hearing reveals why trust has eroded so deeply. Even when allegations turn out to be misunderstandings, the damage is already done. Delayed explanations, incomplete information, and silence create a vacuum, and fear rushes in to fill it. The court hears about DUIs, probation, photos, and second-hand reports, but also hears a critical admission: the child was never in the car. That admission matters enormously. Family court draws a sharp line between poor adult choices and direct risk to a child. Still, patterns of behavior cannot be ignored. What the court is really evaluating here is credibility and trajectory. Is this a parent moving towards stability or away from it? The request for a full evidentiary hearing underscores how unresolved these concerns remain. This isn't about winning today, it's about determining whether safeguards are temporary stepping stones or long-term necessities.
Prior discussed orders, that is what he should be having right now. He was trying to work towards resolving the issues that would satisfy lifting the supervision requirement. We restore the supervised visitation, the same schedule they had before. Our parenting plan states that neither parent should be drinking or using alcohol or before or during their parenting time. I think the big hangup is how long that supervision needs to last. My client's position is that supervised visitation should last until he has satisfied one last piece, which is December 1st. He is scheduled to go back before the Wichita Municipal Court to verify that he has completed the piece of the probation agreement that has to do with getting a drug and alcohol evaluation. And he would be in agreement with keeping the supervision requirement in place to verify that he has completed that requirement. So up through December 1st and verification of completion of that.
This is the emotional core of the hearing. The judge speaks directly to the father, not as a litigant, but as a parent. He invokes constitutional rights, then immediately tempers them with responsibility. The warning is unmistakable: if alcohol ever outweighs a child's safety, those rights collapse instantly. Notice the balance in the judge's tone. There is no accusation, but there is no softness either. The court acknowledges there is no evidence of driving drunk with the child, while making it painfully clear that one mistake would change everything. This is judicial realism at its finest. Family court is not about past punishment, it's about future prevention. The emphasis on grandparents, supervision, and structure reflects the court trying to build a bridge, not burn one. But that bridge only holds if the parent does the work.